The Women's Health Protection Act of 2017 is promoted as pro-abortion legislation. But rather than focusing on this controversial topic, I want to look at the constitutional train wreck Congress is trying to impose on the states. We'll take a look at this next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there again, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and teach the rising generation to be free. I am glad you could join me today. As always, head to the website, constitutionstudy.com. You'll see everything we're doing Constitution Study. I've started a new Twitter hashtag, so look for hashtag Constitution Study on your Twitter feed. You can find out everything that I'm putting out related to the Constitution Study. I want to thank everybody that helps me get this message out, helps me share this message, whether it's Conversations on the Culture, Restore the Intent, Constitutional Grassroots Movement. These are all people and organizations that are sharing. They think this message is important. They want it shared with the rest of Americans. I hope you'll join me in that. I hope you'll join me in sharing through whatever social media, through whatever process, with your friends, with your family, what you're learning here on the Constitution Study. Most importantly, the desire to actually read and study the Constitution for yourself. So let's get into today's message. You know, it seems to me that titles of bills really mean the exact opposite. See, like a lot of modern legislation, this Women's Health Protection Act ignores what the Constitution says in favor of winning political brownie points. See, our ignorance of the Constitution means that those we hire to represent us, more often than not, are just pulling the wool over our eyes. Now, the House rules say that in order to enact legislation, there must be a constitutional authority statement. You see, House Rule 12, Clause 7C requires that to be accepted for introduction by the House Clerk, all bills and joint resolutions must provide a document stating, quote, as specifically as practicable the power or powers granted to Congress in the Constitution to enact the bill or joint resolution. Now, since 2011, House Rule 12 required that any House legislation had to show specifically where Congress received the authority to enact such legislation. With chutzpah that staggers the belief, Representative Judy Chu, who sponsored the legislation, along with her co-sponsors, claimed that authority under Article 1, Section 8, Clause 1. According to the legislation, H.R. 1322, Congress has the power to enact this legislation pursuant to the following, Clause 1 of Section 8 of Article 1 of the U.S. Constitution. Now, why do I say this statement requires chutzpah? Because Article 1, Section 8, Clause 1 of the U.S. Constitution says, quote, the Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. See, this legislation has nothing to do with collecting taxes. In fact, the words tax, duty, impost, and excise don't even appear in this legislation. Now, some might argue that it falls under the, quote, general welfare clause, but there are two issues with this argument. First, Clause 1 does not give Congress the power to legislate for the general welfare, only to collect taxes. Second, as James Madison stated in Federalist 41, the general welfare clause is not a blanket authority for Congress to do whatever it thinks is in the general welfare of the United States. Quote, it has been urged and echoed that the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States amounts to an unlimited commission to exercise every power which may be alleged to be necessary for the common defense or general welfare. No stronger proof could be given of the distress under which these writers labor for the objections than their stooping to such a misconstruction. Had no other enumeration or definition of the powers of Congress been found in the Constitution, then the general expression just cited, the authors of the objection might have had some color for it, though it would have been difficult to find a reason for so awkward a form of describing an authority to legislate in all possible cases. Continuing on, for what purpose could the enumeration of particular powers be inserted if these and all others were meant to be included in the preceding general power? Nothing is more natural nor common than first to use a general phrase and then to explain and qualify it by a recital of particulars. But the idea of an enumeration of particulars which neither explain nor qualify the general meaning and can have no other effect to confound and mislead it is an absurdity, which, as we are reduced to the dilemma of charging either on the authors of the objection or on the authors of the Constitution, we must take the liberty of supposing had not its origins with the latter. You see, in a contest between those who wrote the Constitution and those who interpret it, we're supposed to follow the ones who wrote it. See, apparently Congress thinks we are too stupid to actually know what they are and are not authorized to do. Apparently they think we won't bother checking the specific power they wish to exercise. Oh wait, most Americans don't know what powers Congress has and never bother checking before supporting legislation. See, Representative Chu goes on to insult our intelligence by claiming that Congress has the authority to pass such legislation by quoting other parts of the Constitution. Item 9. Congress has the authority to protect women's ability to access abortion services pursuant to its power under the Commerce Clause and its power under Section 5 of the 14th Amendment to the Constitution to enforce the provisions of Section 1 of the 14th Amendment. This to me falls under the heading of, if you can't dazzle them with brilliance, baffle them with baloney. So let's take a look at that Commerce Clause. Quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Simple, sweet, to the point. There is nothing in this legislation about commerce. Nothing at all. This legislation is all about telling states what laws they can and cannot pass with regard to abortion. What about the 14th Amendment? Well, Section 5 says the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. Okay, Congress can pass laws to do their job under the Constitution. This is redundant language that's been added to many of the latter amendments. It's redundant because Article 1, Section 8, Clause 18 already grants Congress the power to enact legislation to exercise its powers. Quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. So Congress already has this power. So she's just padding. You know, in college they called this padding. You're just adding stuff to make it look like you have a better argument. But it says Section 5 to support what they want to do in Section 1. Okay. Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So here, we finally get to something at least related to the legislation at hand. The purpose of the 14th Amendment is to prohibit states from making or enforcing laws that abridge the privileges or immunities of citizens of the United States. They're also prohibited from denying anyone the life, liberty, or property without due process of law. Now, while the Supreme Court has held that a woman has the right to obtain an abortion, this is based on a precedent from Roe v. Wade case, which was a case about privacy. The privacy question around the abortion decision, and concluded, quote, that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests and regulation. What I find interesting in placing the authority on the 14th Amendment is that the requirement that no person may be deprived of life, liberty, or property without due process of law. Yet this legislation ignores the taking of a human life just because it's inside the womb. See, I thought Congress was empowered to enact legislation to protect life, liberty, and property of all persons, not just those of a class they prefer. This legislation effectively places a burden of proof on the state to show why medical facilities and practitioners need to be regulated that is not placed on any other medical facility. See, when I go to an outpatient medical center, does that center not need to maintain standards set by the state? But according to this legislation, the Attorney General of the United States can sue a state if anyone claims that said regulation was targeted at facilities that provide abortions. Would you want your wife, your daughter, or yourself to go to a clinic that didn't meet those basic medical standards? And just to put the constitutional icing on this particular cake of nonsense, nothing in the Constitution gives the federal government, including the Supreme Court, the authority to determine regulations for medical care. If a state legislature, in their role as representatives of the citizens of their state, wish to exercise the power which was recognized by the Supreme Court in the Roe v. Wade case, why should Congress stick their noses where they have no authority? Apparently those in Congress think the American people are too stupid to know what powers the Constitution actually granted to them. Or maybe they just think we're too lazy to bother looking up their constitutional authority statements, so we won't see just how ridiculous they are. Or maybe we've trained them not to worry about keeping to the supreme law of the land because we won't hold them accountable. See, regardless of your position on abortion, our position on the Constitution and the role of Congress should be firm. Stick to your oath to support the Constitution, or we'll find somebody who will. So what do you think? Is Congressman Chu trying to overstep her bounds? Has Congress as a whole just decided they're going to ignore the American people and pretend they can do whatever they want? That they can misread or basically ignore the Constitution at will? And will we hold them accountable? That's the real question. Will we go back and say, okay, this makes no sense, this makes no sense, this makes no sense? No. See, that's the part that we've lost. That's what our educational system has destroyed. This nation is founded by we the people. We the people tell Congress what it can and cannot do. And it's about time we start enforcing the rules we put on them. They're not going to enforce it on themselves, folks. If we put it on them, it is up to us to hold them accountable. And if they won't, then we need to find people who will. Because if we don't, the Constitution doesn't matter anymore. And laws don't matter because it now is going to fall to, well, whoever can scream the most or get the most attention on social media or basically just appear to have a great case. This is not a message about abortion. It's a message about a blatant example of bad legislation, unconstitutional legislation, unconstitutionally founded, and just assume the American people will play fat, dumb, and happy. It's time we stop being ignorant and apathetic. It's time we actually educate ourselves, because the government won't, and we start taking action to hold those who work in our name accountable to we the people. So I hope you enjoyed that message. I hope you'll follow me. Head over to the website, constitutionstudy.com. Most of all, I hope you'll stop and think, just because you happen to like the title of a piece of legislation, it may be worth going in a little deeper and seeing what it's actually going to do and actually finding out if it's constitutional or legal or not. Hey, head over to the website, maybe check out one of these videos, see if there's more you might want to learn about the Constitution. Most of all, I hope I'll join me again right here on the Constitution Study.